Good morning.
Good morning.
Good morning, Judge.
Okay, so what I have for this morning, for at 9 anyway, is Ms. Johns and the City of Atlanta, Justice Murdaugh versus the City of Atlanta. I've seen some email traffic that would seem to indicate that the parties have maybe figured out that they don't need me anymore in whatever way, either or both, because the case has been fully resolved or because um, the city wants to remove or withdraw its request to transfer the case to me and send it back to the magistrate or municipal court or both. What are you, Ms. Johns? Let me start with you. What is your belief about the status of the case and what, if anything, the court needs to do with it today?
Thank you, Judge. I had hoped that we would be in a position today where I would agree that the court has no further duties to this case. But the city filed the recent filing this week by the city indicates to me that we still disagree. The most confusing aspect of this filing, I do not believe the appellate code under which we practice allows the city to grant them the thing that they seek in this filing, because it is set up to encourage a decision on the merits of the review. And the city is seeking to avoid that by asking this court to issue an order that throws an entirely separate wrench into these proceedings. What baffles me about this is that they have filed a 12-page motion, and on page 1, they asked this court to issue an order allowing them to withdraw their transfer so that this is no longer a live controversy.
Right, and then they spend the next 11 pages explaining why they were right to have transferred the case in the first place.
So the issue with that is that if the court grants them what they're asking for, that's a totally different issue to argue on appeal than what they seem to be arguing in this motion. So my ask of the court today is to, the city seems to be suggesting that Butler is not dispositive because they didn't make the correct arguments in Butler, and they are making the correct arguments here in this motion. I would disagree with that, and I would ask the court to allow me leave to file the briefs that were filed in both Butler and Paris by the city and by my office, because I think that would be evidence to the court that it is exactly the same argument that we've been arguing at some level of litigation since probably about 2019, but that has been advanced before the Court of Appeals and that the Court of Appeals declined to agree with. In addition to that, I think this court could take judicial notice of the arguments that were put forth by the city at the Court of Appeals, because that's readily ascertainable and not subject to dispute, as it is recorded and posted on the Court of Appeals website. And at those arguments, the court directly asked the city whether the question in my memory was posed: if you believe that you have authority to charge a criminal trespass, because the Municipal Court of Atlanta doesn't have jurisdiction over criminal trespass, then are you also saying that you have authority to charge a murder? And their answer without hesitation was yes. In other words, this has been squarely before the Court of Appeals, and I would ask for leave to file that proof of that before this court, so that if the court agrees with me that in fact this is not a new argument, that the court can then direct the city to file a brief specifically addressing what factual distinction exists between these two cases that leaves any need for the court to do anything other than cite to Butler and vacate the order below based on that fact. If the court looks at these filings and agrees with the city that they are just making a new argument here, and that that's not what's going on, that the Court of Appeals didn't hear the right argument, and that this hasn't been addressed, then the court should direct me to file a brief that explains my position that I think that this argument has been made over and over again, as would be evidenced by those briefs. And in either case, I would ask that the opposing counsel be allowed the opportunity to respond. But what doesn't make sense, given that the city clearly doesn't agree or doesn't think that the Court of Appeals has heard the right arguments, is to take a left turn here and do something that puts us on an entirely different tract of legal arguments without reason. So that would be my ask, Your Honor.
Okay, understood, Ms. Johns. Thank you. Mr. Hopkins, I assume I'm going to hear from you.
Yes, Judge. So essentially, the procedural history on this case is we've got a defendant who was deemed to be non-competent, and they were put into the municipal court by arrest, and we received a citation. After the defendant had already gone through first appearance, he ended up in the arraignment docket, then status and whatnot in Judge Ward's courtroom. And the issue started to revolve around if you have a defendant who is non-competent and the city does not possess a contract with Department of Mental Health or Behavioral Health to restore that person to competency, what do you do with that person? Especially in the wake of Paris, which talks about individuals getting rights to have probable cause challenges and things like that. In this case, the argument was made by the public defender's office that this person cannot have a Paris hearing to have the case possibly transferred to state court or superior court who has contract with the state to evaluate and treat somebody who has been deemed to have be non-competent, because there's the provision inside of the competency statute that talks about the 90-day period that a person has after they've been found not to be competent, see if they can be brought back to competency. We can't do that in city court because we do not have a contract with them. So essentially, we're getting to the point with these individuals who are not competent that they're coming into court, they're being found to be not competent.
Forgive me for interrupting you, Mr. Hopkins, but just logistically help me understand one part of that, which is how is a person found non-competent? Because of course, the way it typically happens in superior court, right, is that a person is arrested and charged, and then someone appreciates that perhaps they're not fully in charge of their faculties, and then they get evaluated and someone determines that they're not competent. But those are all things that typically flow from DBHDD involvement. And so I guess one question I have is, how is it that the city is determining that someone like this individual isn't competent if they don't have contracts with the types of entities? Is it because they have charges in another court that does have connection to DBHDD? How did that happen?
No, the public defender's office is obtaining evaluations.
I see.
And after the evaluation is done, they're then presenting them to the court to say that this person is not competent. And then whenever we sent them to, or attempted to send them to behavioral GRN, they're advising that because we do not have a contract with them, they cannot go ahead and restore the person or attempt to restore them to competency. They can do the evaluation, but they can't go ahead and restore them to competency.
Right.
So at that instance, we were requesting Paris hearings to have the person transferred to the state court who does have the contract with them for them to do the restoration. At that point,
that would certainly be a substantive issue that the defendant, if they're not competent, would not meaningfully be able to participate in.
And that's the issue we're run into. At that point, the defense counsel is saying, well, this has to be dismissed because the city can't handle it at all, where it kind of creates this limbo where we could potentially have individuals who are out and about committing crimes in the city, and they're being charged with city ordinances, but they could never have anything ever done to them by the city court on these city ordinances, and we can't give them help.
So, Mr. Hopkins, I think as I understood the city's motion to withdraw, right? It was, I understood the city's position. Maybe I understood it incorrectly, and please tell me if I did, that if the case goes back, that if the court gives the city the relief it wants, right, then it would essentially undo any effort at a Paris hearing, and the case would remain in the municipal court. And then presumably, if the defendant is not competent, then the state would dismiss, or those charges would go away, at least in this particular instance. Is
You're
that
right.
what the city intends?
And essentially what we did, because the goal here is to make sure that these people like don't end up just getting involved in the system where they get charged, they get released, they get charged, they get released. If they need mental help, to get mental help. So we have attempted to, whenever we had the challenge that there we should not be able to send it to the state court, we went ahead and bypassed this next part by asking the officer to then go ahead and seek out warrants and get warrants on the underlying offense so that it could be directly filed with the state court so they could handle it. So that happened after the appeal was filed because we wanted to make sure that, you know, as we have a constant problem with individuals who are on the streets and mentally ill, keeping a location on them is often very difficult, especially for evaluation, much less restoration of competency. So we were attempting to not have this break down that time period. So that's when we asked them to go ahead and take out the warrant. As a result of that, they do currently have warrants that are active in the state court. If the state court and the solicitor's office there determines that, you know, whatever they determine, whether they put them in or attempt to refer them to Georgia Regional or they do not, the city has done everything in our power at that point to go ahead and facilitate that in a world of Butler. But at the same time, the city is also saying that, you know, we understand, we disagree with the ruling in Butler because we believe there were other arguments that were made that were not heard by the Court of Appeals. Mainly, there's a part in our motion that states that the arguments that we were trying to really raise about this being a court of inquiry, those weren't brought up originally in the original hearing. So therefore, because the record was silent on that, that's what the footnote we brought up, that they said because those were mooted essentially. You know, if it gets back to that point where we need to have the argument about whether we're a court of inquiry and what the limitations are for the court of inquiry as it pertains to offenses that should be heard in the state or superior court. We do want to go ahead and sleep on those and have them, you know, waive our argument essentially. We're just saying in this point, in this case, it's kind of mooted because we have already gotten the warrants in the state court, and we're just asking this to be transferred back to the city so that we can dismiss our warrants and just let them proceed on the warrants in the state court that have already been filed.
Okay. Mr. Hopkins, what about Ms. John's argument that that by doing that in this particular instance that somehow constitutes a prejudice to her client because you're essentially doing an end run around Butler and sort of starting all over again from a procedural perspective, or making him start all over again?
We would not be Butler or Murdow.
Forgive me. No, I did not mean to say that. Go ahead.
Okay.
I'm asking, my question is, I'm asking about her. I mean, primarily, as I understand her argument, is that allowing you to withdraw the claim, send it back, that essentially requires her client to just sort of start all over again when, by dealing with the state court charges that have been filed because they've already been filed in this case.
Correct.
What of that issue?
That is unfortunately where that defendant is going to lie, and that's kind of the point here, is that we're trying to create a process where we have individuals like what do we do with people that are mentally ill or not competent that are charged with city offenses that you know, need to have some type of treatment or help and possible restoration. In this case in particular, we would have liked to, it would have been a lot easier if there had been a direct path from the arrest, them determining non-competency and it being transferred directly to state court. That's would have been the best path. And unfortunately, that was not done in the in first appearance. It wasn't done at arraignment. It wasn't until status after that point the non-competency was determined that we were able to do this after we had already started. So we're attempting to get it to the right place. And this would put it at the right place. And unfortunately, because there hasn't been, there's a lack of contract parity between ourselves and behavioral health, this is the best that we can do upon the first notification that they're not competent to get them to the right place. So
Understood.
the city has not attempted to protract this out. We haven't tried to prejudice the defendant at all by this. The simplest thing would have been to have had defense counsel advise that they are not competent and that the proper place where they would have the ability to work on the competency would be state court, but they oppose that. So we've done the best that we can with the limited tools that we have in the municipal court.
Thank you, Mr. Hopkins. Ms. Johns, I guess one
Yes, Your Honor.
question I have is, I mean, I understand and I am aware of, you can't, I guess, consider it in a vacuum. I understand and I'm aware of this, the other warrants that have arisen in state court that would result in a fully separate prosecution. But at its most basic, in this case, as I understand the city's position, if I allow them to withdraw the request to transfer the case, then it goes back to municipal court, and under the current circumstances, it goes away. Granted, your client would essentially have to start over again relative to the state court charges, but why separate and apart from that procedural issue? Generally speaking, there's not prejudice to a criminal defendant when the governing authority is offering to dismiss those charges. What is your response to that?
I'm not sure I understand. Correct me if I start into this and I'm not actually answering the court's question.
Sure.
But as I understand it, if this court were to vacate that order and issue a ruling on the merits that the municipal court prosecuting attorney doesn't have charging authority over a criminal trespass, and thus that order has to come back down, that would be a ruling on the merits. And I do think that is what.
Forgive me for interrupting you, Ms. Johns, but I'm not sure that's what the city's asking for. I'm not sure the city, I think you're right that the city is seeking to avoid entirely a substantive finding. But rather that as the charging authority, they have the right to withdraw the charge, right? If they're the ones that sought to transfer it, they can ask for it to be untransferred. And if it is not transferred, I'm not sure that the city wants me to make a finding that they didn't have the authority to transfer it, but more that they had the discretion to not transfer it if they wanted to, and now they want to undo that original decision.
I don't think that OCGA 5319 allows this court to do that. I think it requires that this court issue a ruling on the merits. And the court can give the solicitor office what they're asking for and also issue a ruling on the merits. But this court can't just withdraw that decision for them. The court has to issue a ruling on the merits. And in my estimation, that's a question of whether Butler controls. I do want to just address quickly some of the things that were said. The characterization that these defendants are that we are securing mental health evaluations on these folks and bringing it to court is an unfair characterization. The record will show that the first notice that the court had that we felt that Mr. Murdaugh, or I'll say it may not even be the first, but as early as October of 2024, when Mr. Murdaugh was in court on this fare evasion case, our office made the court aware that early that we felt there was an issue of competency. And then the court ordered the city's Department of Corrections to conduct the evaluation. And the record further shows that Dr. Nicole Pass did conduct that evaluation and that a hearing was held in that court. And so I just want to be really clear that our attorneys are not coming back to the office and setting up some private evaluation somewhere and then using that to suggest that the court can't proceed, that this is a process that the municipal court has used for as long as I've been here, for the 10 years that I've been here. And it's not just us going and getting some order from some private psychologist somewhere. The argument that the
Ms.
city's
Johns,
goal.
don't worry.
Yes.
I did not believe that the public defender of any sort had those resources or those abilities. I assumed and understood that it was coming from some. That's why I asked if it was perhaps from another court or through a different set of charges that might have better resources. So don't worry about that.
And the city will
Thank you.
apologize.
And I will say too, that if
to-
opposing counsel is
Hang
arguing,
on.
I'm sorry, if
Sorry, Ms.
opposing
Johns.
counsel is
ahead.
arguing that their goal is to avoid having a defendant in the municipal court continue in this cycle of arrest and conviction and arrest simply because of mental health issues, Justice Murdaugh is the person who has accomplished that. Mr. Murdaugh, there has been no argument that Mr. Murdaugh is competent. What has happened is he did his time at ACDC when he got out on bond, and I suspect it was a signature bond, but I don't recall without referencing the record. His family and his community got involved and engaged him with mental health services. And the record is clear that there was never any cause to revoke his bond after that. This man came back and forth to court for well over a year on this case alone, going to different status updates, different court dates where we secured an order seeking an evaluation, and he showed up at every court date. There was never cause to revoke his bond. As far as I'm aware, I don't think he's picked up any new charges. And this is simply because his mother got involved and has engaged mental health help for him. This is exactly the defendant who doesn't need the criminal justice system, if that in fact is their goal, because there's no evidence that this has been a continuing problem for him.
So, Ms. Johns, let me ask you from a logistics or, a more basic perspective. So the the city, as I understand it, would have me grant their motion to withdraw and send it back. And then they'll take whatever steps, which they've represented to me would be a dismissal because the state court charges have separately been filed. I think I understand from you, and if you'd clarify that for me, Ms. Johns, that you don't necessarily object to the charges returning to the municipal court, which doesn't have the authority to act on it, but you want it to be accompanied by a substantive review of the legal issue by the court and a ruling on that issue that the case necessarily must be returned because the state didn't have the authority to have the hearing that it had to get the case transferred in the first place. Is that accurate?
Very close, Your Honor. There was no hearing. That's the problem. And if we had gotten to that point, I do agree with opposing counsel that we might have a different argument for this court. And at least in that event, we would be moving forward with this argument. They're not rehashing the same argument that has been made time and time again, but here we are doing that. So specifically what I would ask is if the court issues that order with findings of facts and conclusions of law and a question of whether or not Butler applies, it specifically addresses what the city has put as its argument in this motion to withdraw, because as best I can tell, I mean, what I would like to see happen in this case from the legal argument perspective is not the same argument over and over. So as best I can tell, the city is at least suggesting to this court that they just didn't make the right argument in Butler. So if they believe that there's a factual distinction, lay it out so we can address it and we can move forward with this argument. If they don't think that there's a factual distinction, then I'm asking this court for leave to file the brief so the court can make a decision, has this been addressed? And depending on that decision, can refine our arguments. If the court agrees with the city that it's a new argument, then this court should direct me to file a brief arguing against that if I believe. And otherwise, the city should be compelled to argue the factual distinction, but not the same thing over and over. And certainly this case is evidence of why it is so frustrating. Because if in fact there is still a substantive disagreement, it should be positioned to get us there. But it is not, because the city is avoiding that. And I'm asking the court not to allow that to happen and to try and refine the argument a little bit so we can at least cover some new ground.
Okay.
I want to point out that there are multiple ways to move this case over that do not involve a hearing, do not involve a warrant. But the argument the city continues to advance that they simply cannot put resources into restoring city defendants to competency in order to prosecute city ordinances is a bit disingenuous. They have just chosen not to. I'm not suggesting it would be easy.
Right, but that's a policy decision that's not really before the court today.
But it is not a reason to grant the city the relief that they seek, because it is not a real reason. They don't need Fulton County to restore somebody so that they can be prosecuted for fare evasion. And every attempt to move these cases over, whether it be by getting our court to issue a ruling that there is cause for this charge to move forward, or going and getting warrants so the kid ends up in Rice Street before anybody can look at the case and make a decision out of the complaint room, all seem to be designed to get around the fact that the county solicitor for Fulton County has prosecutorial discretion and can exercise it and should be entrusted with that.
Thank you, Ms. Johns. Mr. Hopkins, let me ask you one last question. So I think what I understand Ms. Johns to be presenting or proposing is not necessarily that I grant her motion outright today, but that the court engage in some further briefing on this issue. I mean, I have to say, I understand that there are much more significant policy, financial, et cetera, criminal justice decisions at play here, but it does seem like a lot of resources for a fare evasion charge. I understand it happens enough that we're not really just talking about this particular individual. I hear that from Ms. Johns. I'm hearing that from the city. But logistically and procedurally, if the court is not inclined to, in this moment, as a discretionary matter, simply allow the city to withdraw its transfer, what would you have the court do from a next steps in terms of considering the substantive legal issue?
We would want you to go ahead and take a look at the fact that the initial argument that we feel wasn't addressed by the Butler decision, which is that as a court of inquiry, we kind of direct a lot of the traffic as it pertains to cases upon first blush that happen in the city of Atlanta, and we make sure they go to the right places. And there's a big chilling effect that Butler has on just quite frankly, the way that the municipal court has worked traditionally. Like we used to handle every single case, misdemeanor to felony, that happened in the city at some point. And over time, more of that's been passed along to the state court, but it doesn't change the fact that we are a court of inquiry, and the public defender's office in the municipal court has systematically attempted to remove all of our abilities to actually function as a court of inquiry by taking these necessary powers that the city has to move cases to the proper jurisdiction. They've attempted to chill that and move it, or stop us from moving cases, which is in complete contradiction to the purpose of a court of inquiry that has specifically been carved out for us. So, the arguments that we would make would be ones that, we feel were not addressed by Butler. This is definitely a defendant who is differently situated than the defendant in Butler. Now, not only do we have the mental health issue, but the city has been barred essentially by objections by the defense to handle things in accordance with the way that Butler said things should even be handled, by saying that we can't have these hearings that have been delineated out. I would argue that that's what we would have to do. But, in this instance, we've requested to be transferred. We're now requesting that it not be transferred because we handled it another way. And I apologize for, I did not know who the evaluator was. I just was given an evaluation by the public defender that had the defendant listed as non-competent. I didn't know what the source of that was. There was no intent to impugn anybody as having private psychologists on hand or psychiatrists on hand. End of the day, our attempt in this, and that's why we filed this motion to withdraw our request for transfer, is we're trying to get this person to where they need to be so that they can get their case handled quickly and efficiently. And, while not necessarily in this case.
Well, I think that ship has sailed in this case, right?
Sure.
This has not been handled quickly and efficiently by any measure.
Sure. While Mr. Murdow, while he might have the support network, we have a lot of defendants who do not have that, and we're trying to make sure that going forward, this isn't a problem. That we know where we're going, how we're doing it, and what path to take. Because we keep getting these individuals who are in custody and who are out of custody that have mental health issues, and we don't have anything to do with them in the city court. And we're being told that we can't handle them, but we can't transfer them to somebody who can handle them. And that's a complete anomaly that should be addressed. And we believe that, that's something that wasn't contemplated by Butler. If you have somebody who walks into court, they have had disorderly conduct charges, but you find out that the victim has grievous injuries, and maybe the officer is no longer there. Who do we have to go ahead and handle this? Like, the city's trying to go ahead and make sure that these go to the right place. And, that's what it's attempted to do here. And the easiest thing to do would be to grant the city's motion to go ahead and send it back to us so we can dismiss it and proceed on the state warrant, which was the city's intent to make sure that this was an avoidable situation.
Okay. So to put a fine point on it, from Ms. Johns, I think she posed a question to the city about whether you think there's a factual distinction here or not, in terms of whether that would require additional briefing. I think I heard you say that the facts are importantly distinct from the Butler case.
I would say that my understanding of the Butler case is, and I did not handle that case myself. The issue where it hung up there was, I believe it had to do something with, what was it in particular?
Well, I'll save you the trouble, Mr. Hopkins.
Sure.
I think that you have essentially agreed with the argument, the statement question that Ms. Hopkins had posed, which is that the city's position is that there is a meaningful difference here between the circumstances of this case and the Butler decision, such that it should not be dispositive of the outcome here. And I think that's what I understood Ms. John's question to be. And if I'm understanding that correctly, I think that Ms. John's request for some additional briefing might make sense. But I would be likely to do it on a really short turnaround. If the court were to invite Ms. Johns and the city to provide some additional briefing, would you want it to be, I can do it one of two ways, right? Given the two parties' divergent positions, I can say, okay, each of you submit a brief to me within the next 20 days, outlining what you believe is the differences with Butler or the similarities to Butler, et cetera, legally and factually. And then each of you would get an opportunity to reply. Or I can say, hey, Ms. Johns, file what you want, or hey, city, file what you want, and Ms. Johns would get a reply. Given the parties' sort of entrenched positions, I think I'd be likely to say 20 days, everybody file what you want me to consider, and then I'll let you have a 10-day after that response to each other. Ms. Johns, what are your thoughts on that approach?
My biggest concern is that I don't expect to hear any new art. Can the court hear me?
Yes, I
It
can.
looks like my video has cut off.
Your video has not been on the entire time, but since I know who you are,
Okay.
I'm not worried that you're trying to pull anything past me, Miss John. So
I'm not a cat, Your Honor. um, I don't know why it shows to me that it should be on, but I can see that it's not. My concern with that is that it doesn't refine the issue. I'm happy to do that if the court determines that that's the best course of events here. But in particular, this last filing by the city suggests that unless the city is required to refine the issue, this court is going to get briefs that are essentially likely, in my estimation, the motion that they filed this week is really the same argument that they filed in their brief, and is really the same argument that they filed in their response, and it's the same argument that was advanced in Butler, and quite frankly is founded on a lot of the same legal argument that was originally argued in Paris. And the city is not distinguishing that at all. And I'm asking the court to allow me just to file the briefs that we are referring to, that we disagree about what they said, just so that the court can make a decision whether those briefs actually, I think the headers of the brief, Your Honor, the brief in opposition that the opposing counsel's office filed in David Butler in the Court of Appeals has 6 points of argument, including this court should recognize that the General Assembly's constitutional authority under Georgia Constitution, et cetera, confers by law upon municipal courts jurisdiction to prosecute state misdemeanor offenses while sitting as a court of inquiry. That's just the first point. It is the point that they are advancing here. And
well,
unless
Ms.
this
Johns,
court,
I apologize. So we've been chatting for almost 45 minutes, and I feel like we're coming back around to where we were before, and I don't know that at this point the further substantive argument is helpful to me, because that's
yes,
something that I think what I need is what you're offering, which is to supplement the record with some of this additional information. Now, whether it's outcome determinative or not is a different matter, but I understand your position. So here's what I'm going to do. Ms. Johns, I'm going to give you 10 days to supplement the record with whatever you believe is necessary in terms of considering the substantive issue. Beyond that, if the city wishes to make a different or alternative argument based on that supplement, i.e. that it's not binding or outcome determinative unless it was, decided upon by the Court of Appeals, et cetera, then the city will have 10 days after that to do so. But to Ms. John's point, it really ought to be something marked, an assessment of the substance of those arguments, and not merely a rehash of the additional issues that we seem to go round and round. And then if the court, once the court has a chance to review those materials, I will either set another hearing and advise the court, the parties, what we're going to talk about in a little bit more detail, or I will advise the parties that the court's going to make a ruling based on the materials that are in front of it at that point. Does everybody understand that plan?
yes.
Okay, so I don't know if the 26th of January, as I sit here now saying you have 10 days, the 26th of January is, that might, okay, so the 26th of January, and then 10 days beyond that would be the 6th or 5th or 6th of February. Mr. Hopkins, I think I understood Ms. Johns to be, that was okay with her. What about you, Mr. Hopkins?
That should be fine. I
Okay.
don't see any issues with that.
Okay, excellent. Well, then I will look for that additional supplement from Ms. Johns, and then any response that the city wishes to pose, and I will try to get the parties a response, either additional hearing or some ruling, as quickly after that as possible. Okay?
All right. Thank you, Judge.
Thank you both. Have a good day.
You the same.
Counsel who is here on the DEPCOM matter, and or I have a criminal plea I need to take somewhere in here. If you guys will give me just about 5 minutes to get another cup of coffee, I will be right with you, and you'll have my undivided attention. Thank you all.
I've got mine, Your Honor.
Frank, how are you today?
I'm doing well. How's everybody?
That's good. Good.
Doing well.
Good.
Is my video not working? Let me try to go out and back in. Is it
Okay.
is it working or no?
Yeah,
I don't
we're
see
not
you,
seeing you,
Julie.
Julie.
All right, I'll be
I
right
think the little toggle on your camera is covered.
The toggle on my camera is covered. No, there's like a little picture of a camera on mine. I'll come right back.
Okay. Let me ask while it looks like we have our court reporter on. Is that right?
That is right.
Excellent. Hmm. Hmm. Hmm.
Hello.
Hello?
Hi. I've been on a Zoom call in front of Judge Krause, and my internet dropped, and this is the number that the notice gives me to call in. I don't know if I'm calling the right place. Is this?
You're calling the right place. What matter are you appearing before Judge
Thank-
Krause?
It's the Murdaugh v. City of Atlanta.
That may have
Literally-
I don't know, that may have just finished.
I think it
Okay.
did.
Who am I speaking with? I'm sorry.
My name is Bill Buhay. I'm a lawyer in Atlanta, and I'm about to be on a status conference with Judge Krause
Perfect.
on an
Okay.
unrelated matter.
Okay, well, let me try another way then, because I think that, just in the middle of getting the order about what we're all supposed to do, my internet dropped, so I don't know what I'm supposed to do. So,
Yeah.
Well, Judge Krause has stepped away. She'll be back any moment. And so, what was your name, ma'am?
My name is Amanda Johns.
Amanda Johns. All right, Amanda, when Judge Krause comes back, we will let her know that you were here on the City of Atlanta matter, that I joined late. I think that hearing may have started at around 8:45 or 9 o'clock, but
Yes.
I think it is concluded. But
Okay,
Amanda Johns, you said?
that's correct. And I
All
was
right.
literally just arguing. So
Hello.
I'm also just going to.
Hi, Ms. Johns.
Yes.
Thank you, Mr.
Hello.
Buhay, for I heard you just at sort of the last second. I appreciate that. Ms. Johns, did you
Yeah,
have
I apologize.
an issue?
My internet just went out as I was checking my schedule with reference to that January 26th date, and I just called the number that was on the notice, and that's how I
Okay.
got to that gentleman. But yeah.
Okay, well, did you, I mean, I was not aware that you had dropped off. Once I concluded, I thought you were still there. My main concern would be, did you not hear what my ruling was in terms of the time deadlines or anything like that?
So my understanding, Your Honor, was that I had 10 days to supplement the record and file everything by the 26th, that the city has
Yes.
10 days after that to respond, and that the
That's
court will let
correct.
us know if you're going to, and that's my understanding, and I'm good with all of that. So
Yep.
if that's all, then yeah, okay.
That's
Thank
the
you.
ruling, Ms. Johns. You didn't miss anything after that. I just said I was going to get some more coffee. So
Thank you so much.
thank you, Ms. Johns. Have a good day.
Bye-bye.
Okay. Mr. Estroff, I assume you are here to take down this scheduling conference. Is that right, sir?
That is correct, Your Honor. And the
Okay.
only thing I ask is when everyone begins speaking, if you could just state who you represent for my my record, that would be good for me.
It's helpful for mine too, Mr. Estroff.
Very good.
Just to give you a place to start, I'm going to call the cases. This is going to be a case management conference in the matter of 4/5 cases that were filed by DEPCOM Power Incorporated versus various entities related to the various power plant construction disputes. I'm also aware that there's a fifth case that the parties are moving to add. And so and so we will go ahead and talk a little bit about that today. First, I'd like to start by thanking all of you for your civility and professionalism in getting to the point that you're submitting to me what is actually an agreed case management order with agreed dates. I'm sure you all know in your litigation practices that doesn't always happen with highly contested cases like these. And so I really appreciate it. It makes my life a lot easier. And frankly, I think it makes y'all's lives a lot easier. So I appreciate that. I'm going to start with counsel for DEPCOM just because they're the plaintiff in all of the cases and go from there. Is that Mr. Mason?
Your Honor, Bill Buhay here on behalf
Bill Buhay, okay.
of DEPCOM. I am joined, Your Honor, by Joe Guarino, Joe Guarino and Chris Burke of the firm of Varela Lee Metz in Guarino from Tyson's Corner, Virginia, and also Arnie Mason from Williams Mullins, also from Tyson's, Virginia area. And also joining us this morning, Your Honor, is Julie Johnstone, who is in-house counsel for DEPCOM Power. And we're here on behalf of the plaintiff in the 4 cases that are currently pending before you and the 5th that we're seeking to have transferred to the Metro Atlanta Business Court.
Okay, thank you, Mr. Buhay. And then who do I have here on behalf of, I'm just going to start in the order that they seem to exist. So Heelstone seems to be a theme that runs through all of them. And then starting with the first one, I have Blackwater Solar, I have Hobnail Solar, I have Bird Dog Solar, I have Wolfskin Solar. Who do I have starting with, say, Bird Dog?
Your Honor, the answer is going to be the same for all of those. Good morning. This is Frank Lowry from the bond rent firm. Me and the people I'm about to introduce represent all of those entities you just mentioned.
And does that include that 5th case that you're seeking to add?
Yes, including the Lyons case, Lyons Solar. All of those are structured essentially the same. Admittedly, we are in the position of counterclaim plaintiff. We consider ourselves to be the plaintiff in the litigation, but we'll see how that plays out. With me today, I have lead counsel for all of those entities, Julie Silva Palmer from the Morgan Lewis firm. I have my colleague, Jennifer Peterson from my firm. And Julie may have folks with her that she wants to introduce that are with here today.
Yes, my associate Caroline Gillette is on the phone as well.
Thank you. Okay. And do I have anyone else that is going to be counsel in this case? Going once? Okay. So I have had a chance to review I'm sorry. Oh, okay. So I have had a chance to review the proposed case management order that was submitted by the parties. Other than adding, a case caption and some other filing matters, it seemed pretty comprehensive and complete. It appeared to me that the parties had engaged in a good faith effort to actually agree on what might be involved in the discovery of this matter. Excuse me. As most of you probably know, since I know Mr. Lowry and Mr. Buhay have appeared in business court frequently. So y'all might be familiar with this process. But the purpose of the business court is to sort of give you a little bit more hands-on, an expectation of a little bit more hands-on handling by the court. We try to be more readily available to the parties in the event of any discovery disputes or anything like that. And to engage in, more efficient motion practice handling to the extent that there are preliminary motions, et cetera, that need to be handled, and then getting us where we need to be because of the multiple sort of overlapping issues that arise. I think the 2 main issues I wanted to make sure we got through today is one's already been mentioned, which is the addition of this 5th case. My understanding is that really what we need to do is just paper the file to confirm its transfer for a couple of reasons. Number one is that the clerk of court, when it was filed, said, "Oh, this is a related case," and went ahead and transferred it to business court.
Oh,
Yeah. So, and even if she had not done that, I can tell you that I believe Ms. Shaver and I, the staff attorney and attorney manager for all of I think she's got a much loftier title than that she's entitled to, absolutely, because none of this works without her. But it's escaping me at this moment. But I think she had already reviewed and confirmed that the internal rules of the business court would allow that transfer if the parties were agreeing without an independent assessment that we typically do, and without the requirement of a payment of a fee because the parties have already agreed to that fee. So I don't believe that you would incur an additional fee, but we do just need to paper that file to make sure that it gets appropriately, that there's a transfer order entered, so it's clear that it will be handled by the business court. The second issue I wanted to address is in the case management order, the parties had indicated that it was their intent to consolidate discovery for all 5 of the cases. Is that correct, Mr. Big Bay?
It is, Your Honor, and if it's okay with Your Honor, Mr. Guarino is, I think, tasked with the job of addressing any substantive issues today. So I'll turn it over to Mr. Guarino, if that's okay with Your Honor.
And I certainly saw his name all over the track changes. So thank you, Mr. Guarino, for being the one that took the laboring oar on that.
And you're welcome. And definitely Mr. Lowry and Ms. Palmer were involved. And we had quite a few calls as you described, Your Honor, worked very cooperatively, and we'll continue to try to do that. And we appreciate the court's time and effort looking at that. Obviously my first time before the court, so thank you for having us. With respect to the consolidated discovery, yes, the parties have agreed, and you saw in the case management order that we'd like the court to administer this for the purposes of discovery as 5 separate cases. Obviously different for the purposes of trial, but of the purposes of discovery, we've set it up that way, and you can see that way in the case management order. So yes, I think is the answer to your question.
Okay, and just confirming that with Ms. Palmer and Mr. Lowry, is that correct?
Yes, Your Honor, that was our intent.
Okay,
That will
excellent.
streamline.
Okay, and honestly, what it will really matter about, I imagine that what will end up happening is that there will either be consistent across the board disputes that the court needs to resolve in terms of discovery, in terms of the scope, or some particular issue is going to come up in one individual case that we'll deal with as it arises. Honestly, the main reason I wanted to just confirm that is that it's our intention to sort of slap a consolidated case caption onto the CMO and then file it in every one of the cases, so that when you see that, you will be prepared for it. It doesn't mean that we've made any substantive decision other than what you've already agreed to, that the cases will be consolidated for purposes of discovery. The third issue was, I understand, I think there was a big pile of pro hoc vice applications that we had reviewed and approved and ordered entry some time ago, and that we've received maybe 3 or 4 new ones. We're in the process of getting those all processed. I think Ms. Shaver had reviewed them and indicated that they appeared to all be in good order and had been approved by the state bar, and that the fees had been filed. It's really just a matter of us getting that on file for you guys. So that will take place pretty soon. I think my intention, just logistically, to keep it as clean as possible, is to paper the transfer of the Pennsylvania case into the business court to make sure that's documented, and then file the CMO with all 5 case captions on it, so that it's clear that all 5 of those cases are joined. Beyond that, because you guys did all the hard work of the CMO, there's really not much else that I needed to ask the lawyers other than, is there anything else that you needed the court to address while we're all here together today, starting perhaps with Mr. Farina?
Yes, Your Honor. Not for DEPCOM. I believe we've resolved most of the issues, and to the extent we do, I'm hopeful and believe that we'll continue to work cooperatively and hopefully bother you as little as possible.
Your Honor, if I may, on the pro hac vice issue, thank you, Your Honor. An order came in last evening in one of the 5 cases. That would be the Blackwater Solar case, where you had signed the PROAC order for Mr. Guarino, Mr. Burke, Mr. Mason, and Mr. Mason's colleague, Meredith Haynes. I don't know that the other three that are currently pending, four, maybe, I'm not quite certain of where the Lyons case is, but so one has come in for sure. And so I just wanted to alert the court of that, to that.
Thank you. And we'll follow up on that and make sure that they get filed in all of the cases as appropriate. Mr. Lowry, Ms. Palmer, anything from the defendant's or counterclaim plaintiff's perspective?
Yes, a little bit of cleanup to bring to the court's attention. The counterclaims that are existing in the four cases that you already had, or the first ones you had, we've got pending consent motions to amend those so that we can add a Koch, as in Koch brothers, but a Koch-related entity.
I do remember, forgive me for interrupting you, Mr. Lowry. I do remember that because when I was reviewing it, it occurred to me, don't think it matters to anything in the world, but you should know that I was involved in some fairly involved commercial litigation against Koch Industries when I was an attorney many moons ago, probably plus 10 years ago.
I'm guessing it had nothing to do with solar facilities, and Koch's role in the case is really
No,
just
sir.
yeah,
it was a high-level executive dispute where an executive had been terminated, and I'm sure you all know how complicated those executive compensation packages can be.
And Koch's role in this really is just as a guarantor, much like Heelstone's role in the case is. So we have those four pending motions that DEPCOM has consented to. Ms. Peterson brought to my attention last night that I had mistakenly believed that with the Lyons case, we could simply add Koch when we filed our counterclaim. But it appears that we need leave to do that in the Lyons case because Koch is not yet a party. I would love to truncate that process by moving orally, and DEPCON can indicate whether it consents. And if so, you could tell us on this conference that we can go ahead and file that.
And I do believe the package of materials that was sent to me, now that you're mentioning it, I do recall that there was a motion filed to take care of that.
We didn't file it in the Lyons case because I thought since we hadn't filed our counterclaim, we could simply name Koch. I don't think that's correct.
Okay.
So if you were to tell me, and I think Mr. Guarino will agree, that we can go ahead and add Koch when we file our counterclaim in Lyons, that would be great.
Mr. Guarino?
Yeah, no objection, Your Honor.
Okay.
That's the intent. I think part of the confusion is just simply that we were doing a case management order for potentially 5 cases with the parties while simultaneously implementing that. And so we did our best, and no problem.
The only
thing. Oh, sorry, Mr. Lowry. The only thing I would say is that in order to, what I have found is that overpapering the file is typically a good thing because 4 years from now, somebody might go back and look and be like, wait, nobody ever gave you permission. And so to the extent that along with that intended filing, you could email over to Ms. Shaver a proposed order granting your oral motion to add Koch Industries as a party, then that way it will be clear in the record that you had authority to do it based on that motion.
That makes great sense. I guess the other thing that we would share with the court is there's a bit of shorthand the parties have found useful when we talk about Blackwater, Bird Dog, Wolfskin, Hobnail, and Lyons. We collectively use the shorthand, the project owners, and that may help as we're talking through this. Julie, I'm sorry, Ms. Palmer, is there anything else that you think for our side we ought to bring to Judge Krause's attention?
No, that was the only thing that I had in mind because I thought to the extent that you're putting together that caption, it might be easier to deal with the motions to amend first. Defined caption on the case management order.
And Jennifer, Ms. Peterson, have I missed anything else or am I okay?
Okay. So the only other thing to add, and you hopefully have already developed that understanding because obviously, there was some initial briefing on a partial motion for summary judgment related to lien issues. Again, I want to compliment you on your professionalism and civility in working through that issue. But I think what you should have seen from that is that we try to be as proactive as possible in terms of if you file a motion of getting it on a calendar if it needs to be heard or getting you a ruling if it doesn't need to be heard. Ms. Shaver is very, very responsive. And then she brings it to my attention when I need to know about stuff. So please continue to stay in touch with us so that issues don't linger when there are issues up to and including, I hope it doesn't happen, but even to the extent that we've had parties call during depositions and ask for, real-time rulings on objections to the extent the parties can't resolve them themselves. So we're really are here to try and provide a service to the parties to get through their litigation as quickly and as painlessly as possible. And so to the extent that we can be a resource for you, please let us. Anything else from the parties? Mr. Buhay, Mr. Guarino?
Not for DEPCOM, Your Honor. Thank you.
Okay. Mr. Lowry, Ms. Palmer?
Not for the counterclaim plaintiffs, Your Honor.
Okay. So what I will do then is we're going to adjourn here in just a moment. What I will do is we will get we'll get an order of consolidation or some sort of order into the Lyons case to make sure that it's clear that it's been joined, that it's been transferred into the business court to accompany these cases. Then I will wait for, in that case, Mr. Lowry's just very brief order authorizing, granting the oral motion to add Coke, is it Coke Solutions? I thought I saw. Okay.
I think
One
that's
of the
right.
Coke entities, right?
Yeah.
And once I have those things, probably beginning of next week, we will then actually file the CMO that the parties have agreed to. But of course, please operate as if those are your marching orders, even though they will not be entered until we make sure that we've got everything properly papered with all the right parties and every case all connected to the business court. Okay. Okay. Well, everybody, excellent. Well, everybody have a good weekend, and I'm sure we'll be in touch over the next weeks. Thank you.
Thank you,
Thank you, Your Honor.
Thank you, Your Honor.
Okay, I see Miss Potter in the courtroom. Can you hear me, Miss Potter? I can't hear you. I think somebody has to unmute the podium. We were discussing this.
Judge, the podium can't be unmuted from there, so let me contact any longer. Let me contact Mitch or either IT.
I think it has to be unmuted. I thought he had already contacted IT, but I thought it had to be unmuted in Zoom rooms or physically in person.
Rooms, Judge. It does in Zoom rooms.
Okay.
Let me contact them and ask them to unmute. We're still waiting on Mr. Murphy. He's in municipal court.
Okay. And we have Miss Potter. We're waiting on Mr. Murphy. I see in the background that it appears that Mr. Burke and his family are present, perhaps, or is that? I can't hear you, so it doesn't matter, Miss Potter, but thank you.
Judge, I spoke to Deputy Smothers, and he did advise me that is Mr. Burke and his family.
Okay. And so really we're just waiting on the defendant and the defendant's the defendant's attorney and our technological hiccup. Okay.
That's correct, Your Honor. I'm calling IT now.
Okay, excellent. So I'm gonna turn off my camera and be muted until y'all are ready for me. But I'll be nearby, so just let me know when we're ready, okay?
Yes, Your Honor.
Thank you.
Thank
you. Ms. Potter, sorry, the reason I called your name a moment ago was to let you know I apologize for attending by Zoom. Ms. German probably let you know my daughter had to have oral surgery last minute yesterday, so I'm where she is. So but I was going to let you know, more recently, I have been conducting the colloquy myself, and I'm not going to be doing that today. So I am going to be looking for you to do that. And just wanted to give you a heads up that would be the case. Thank you, Ms. Potter.
Judge, Mr. Murphy just walked in. I have IT on the phone. They're going to do it for us. 1 second, please. Thank you.
Okay. Like this all thing we got to. It's all one.
This was on a trial calendar, so it was just,
Okay.
we need a little more negotiations.
Well, they'll probably understand. Listen,
What happened in trial?
I don't know. He just went over there.
Okay,
Such as that.
I don't know, my investigators were all headed over there.
I'm gonna call him. See.
No, stay here.
Is Mr. Murphy here? Is he taking a moment to talk with his client? I
Yeah,
can hear you now, Ms. Potter, so.
he just stepped out to have a moment with his client.
Okay, excellent.
We also, do you have an indictment, Judge?
I do. What I'm going to do since I'm remote is I'm going to ask for permission to sign the indictment on everyone's behalf, and then we'll sign it and get it filed.
Okay, gotcha. Thank you.
Okay, thank you.
Yeah, because we're changing the charges. So I'll have that code and everything for you.
Perfect. And we can make those changes. We can make it reflect those changes. Thank you.
Miss Cardy, can you hear me?
Hi, Judge. I can hear you.
Hey, this is
Oh.
this is
Hi. Hi, Ms. Potter.
Hey, do you have the sexual offender documents?
This is from Mr. Burke.
Yes.
Is Mr. Burke going on probation?
Once he gets released.
Okay. I'll email it over to you.
Okay. There's nobody here that needs to fill it out with him and sign?
Give me 1 second, Ms. Potter.
Okay.
You got another football match today, so. Oh, you done?
I'm done.
That's good. That's good.
Mhm.
Friday.
We got Monday off.
Yeah, no, they trying to make us work though. Like they made a list and they was saying like, oh, we might need y'all to go help out at jail. All that.
No.
I'm looking like,
No.
yeah, they trying.
Do you, are you ever in Judge Leffridge's courtroom?
No.
Okay. Because she always has court on Fridays.
Oh, yeah, it used to be Pilgrim.
Okay.
Pilgrim and somebody else.
Mhm.
Yeah, because you know I'm assigned to Dunaway.
Yeah, yeah, yeah.
So yeah. But yeah, this is probably it'd be Pilgrim.
Okay.
She used to be in our courts on Friday, but yeah. Let's see.
And
They
then
got like
you guys have Monday off, right?
got
You guys don't
Monday.
have to come Monday?
Got like a detail to this weekend over
Okay.
there.
For like extra job?
Well, we at the jail, then we got it probably. Hey, she ready for us?
I think so.
Hello, Judge. My client is on his way in.
Okay, excellent.
Been here, Judge. He was just out there speaking with his family.
No, it was confirmed to me when I checked in earlier that he was here. I just was waiting on you to be able to appear from your court, so I was not worried, but thank you, Mr. Murphy.
Thank you, Judge. Sorry, but things took longer than expected in Atlanta Municipal.
That's how it always goes. Don't worry. Ms. Cantrell, can you hear me okay?
I hear you very well, Judge. Thank you.
Excellent. Thank you.
So I don't know, hey, do you like say I do count one? Like count two, five.
Counsel, while we're waiting on Mr. Burke, where we left off was that it was going to be a non-negotiated plea because the parties had not fully negotiated certain aspects of the resolution. I think based on what Ms. Potter indicated to me that there was an agreed downward reduction. Had the parties been able to fully agree and negotiate the plea, or is it still a non-negotiated plea?
There is a downward reduction with a non-negotiated plea to the downward.
Okay, right. Which was, so what we were discussing previously was that the state would agree that that was part of what had been agreed to was a reduction to, I think, sexual battery. Is that right?
That's correct.
But where the parties did not agree was on the amount of time, and they would be, each of you would be presenting that to the court, and the court will announce its decision, correct?
Yes, Judge.
Yes, Your Honor.
Okay, excellent. So whenever Mr. Burke is ready, Mr. Murphy, you and he can come to the podium. And Ms. Potter, I'm happy for you to sort of stay where you are unless you want to go to the witness stand, because so that Mr. Burke can see you while you're asking him questions.
No, Judge, I'm fine here, if that's okay with you. I don't know if you can see me.
I can't, but that's just because those cameras aren't on, but I can see your face in the background and I can hear you quite well, so.
Thank you.
And I guess if we stay on this side, we will not block you from seeing her.
That's perfectly fine. The main thing is we just need Mr. Burke to be able to see and appreciate when Ms. Potter's talking to him, so.
Okay, I'm going to grab them right now.
Okay.
Ms. Potter,
Yes, ma'am.
can you give me a call? I'm gonna give you the number.
Okay, well, we're about to start the plea. Can we talk about this later? Or I mean, after the plea?
I'll send you an email. I need you to read it. It's regarding the plea.
Ms. Cardy, is there a reason to put the plea on pause for this?
Ms. Potter, for the sex offender, I didn't know this was a sex offender plea. And I'm just gonna need you to read some of these conditions to him since you're there in court.
Okay.
I'm going to email you over the forms
Got it. Okay.
that he has to sign.
Stay over here by me, and just the judge can see Ms. Potter behind us there.
Okay.
Okay. So, Mr. Burke, can you hear me and see me okay?
Yes, ma'am.
Okay. So, Madam Court Reporter,
Yes.
this is going to be a plea hearing in the matter of Maurice Burke, case number 25 SC 002-106. I'll note for the record that Mr. Burke and his attorney, Mr. Murphy, are both present in the courtroom, along with the counsel for the district attorney's office for the state, Ms. Potter. I am attending this hearing remotely. I appreciate your accommodation. I was called away on an emergency matter related to a medical issue with one of my kids, and so I appreciate your accommodating me being remote today. I'll also note for the record that the individual who might need to speak with Mr. Burke regarding probation matters and reporting instructions, including registry issues, is also attending this hearing by video. Her name is Teresa Cardy. Mr. Burke, here's what's going to happen in the next few minutes. In a moment, I'm going to ask the state to provide me with either an agreement that the parties that there is a sufficient factual basis for whatever the agreed reduced charges are, or some factual basis from the state. Assuming that there is a factual basis, either by agreement or otherwise, then I'm going to swear you in, and Ms. Potter is going to ask you a series of questions to make sure you understand what rights you have and what rights you are giving up by entering this plea. Do you understand that, Mr. Burke?
Yes, ma'am.
Okay. Now, during this process, if you don't understand something or if you need clarification, you're free to ask Ms. Potter to clarify. You're free to ask me to explain, or you're free to step back and speak privately with your attorney. Do you understand that, sir?
Yes, ma'am.
Okay. Ms. Potter, let's start with this. Can you tell me I understand this is a non-negotiated plea, in the sense that the parties have not come to a full resolution of the amount of time that they would present to the court. But that some aspects of the plea have been negotiated. Can you tell me what those aspects are?
Yes, Judge. Both counts are going to be modified to sexual battery. CGA 16-6-22.1. They both carry a 1 to 5 year sentence. And so we negotiated count 1, 5 to serve 3 years, balance on probation. Count 2, 5 years probation consecutive, which gives us a total of 10 to serve 3 years, with the remaining 7 on probation. Register as a sex offender upon release, get a psychosexual, follow any recommended counseling, and no contact with the victim, Ms. Perkins. And correct me if I'm wrong, Mr. Murphy.
Yes, as to everything, except there wasn't an agreement as to the time to serve. But yes, we agreed to the registry, which I think is required, the psychosexual evaluation, and the any recommended treatment and no contact.
Okay, thank you. Mr. Murphy, for purposes of resolving the case today, is Mr. Burke willing to stipulate that there is a factual basis for the 2 reduced charges of sexual battery in counts 1 and 2?
We do stipulate to a factual basis, Your Honor.
Okay, thank you. Mr. Burke, will you raise your right hand? Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Thank you, sir. You may lower your hand. Ms. Potter, if you'll go ahead with the colloquy, please.
Yes, Judge, thank you. Mr. Burke, I know I'm behind you, but you can see me on the screen. Can you see me kind of?
Yes.
Is that okay? Okay. At this time, are you taking under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you haven't taken today?
No.
Can you hear him okay? How old are you?
22.
And how far have you gone in school?
12.
So you graduated?
No.
No. Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Okay. Do you understand in indictment 25 SC 002106? The state is modifying the two charges to sexual battery, which is OCGA 16622.1.
Yes.
Okay. And do you understand those are both felonies, given the fact that the victim was under 16 at the time?
Yes, ma'am.
Okay. Do you understand that you have the right to plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial?
Yes, ma'am.
Okay. Have you gone over all of your rights with your attorney, Mr. Murphy?
Yes, ma'am.
Have you had enough time to speak with Mr. Murphy about all the facts and circumstances known to you regarding the charges in this case?
Yes, ma'am.
Okay, including any and all potential defenses?
Yes, ma'am.
And do you need any more time to discuss the case with him?
No, ma'am.
Okay. And Mr. Murphy, do you waive formal reading of the indictment?
So waived.
Okay, and do you waive any and all defects?
So waived.
Okay. And the state is not aware of any outstanding warrants on these on this indictment or these charges. Are you, Mr. Murphy?
I'm not aware of any, no.
Okay. Judge, will he be able to withdraw his plea?
No, because the matter is set on a trial calendar, I believe.
Okay. So, Mr. Burke, this is what's called a non-negotiated plea or a blind plea, which means the state's going to give their recommendation to the court and your attorney's going to give his recommendation to the court. And then the court is going to actually decide on the final sentence. Since it's non-negotiated and we're at the trial calendar, whatever Judge Krause sentences you to, you cannot withdraw it. As opposed to a negotiated plea, if you didn't like or want to go forward with the sentence after she announced the sentence, then you'd be able to withdraw it. But you cannot withdraw it here. Do you understand that?
Yes, ma'am.
Do you understand that this is a guilty plea which will permanently be recorded on your criminal history?
Yes, ma'am.
Okay. And do you understand too that the court can sentence you to a higher sentence than what the state has recommended?
Yes, ma'am.
Okay. These two charges amount to a total of 10 years. So you're looking at a maximum of 10 years in custody. Do you understand that?
Yes, ma'am.
Okay. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or violate any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes, ma'am.
Okay. And do you understand you're not allowed to use or possess a firearm while on probation?
Yes, ma'am.
Okay. Are you a United States citizen?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Okay. Do you understand that by pleading guilty, you're giving up certain rights, and I'll list those out to you. That's a right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. So essentially, by entering this guilty plea, you're giving up or you're waiving all those rights I just listed. Do you understand that?
Yes, ma'am.
Okay. Is anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Okay. And is it your decision to plead guilty because you are in fact guilty?
Yes, ma'am.
So how do you, an indictment 25 SC 002106, how do you plead to the modified charge of count 1 sexual battery?
That's, you have to just announce that you.
How do you plead?
Guilty.
And count 2 sexual battery 16622.1 as well. How do you plead to that count?
Guilty.
Okay. This guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
And do you understand that you have only a limited right to appeal this guilty plea conviction? For these felonies, you have 4 years from today, you've got 30 days from today to file a direct appeal, and you have 4 years from today for this felony charge to file what's called a habeas corpus petition, and that challenges the voluntariness or constitutionality of what's going on here today. So those are 2 time limits that you must be aware of. Do you understand?
Yes, ma'am.
Okay. Thank you, Mr. Burke. That's all I need from you. Judge, as far as I am aware, Mr. Burke does not have a the only thing I would like to add is, given the fact that the DNA results are still pending, and we were on a trial calendar, the court or the state has modified or reduced this to sexual battery. The victim is okay with this sentence, as she was ready to testify, and she was 13 years old at this time. Given all of those facts, Judge, we ask that you accept the 10 to serve 3 recommendation from the court. And at the time the court feels it's convenient, the victim, I don't believe the victim is on, but my advocate, Ms. Kristen Clark, is on, and she has a impact statement that the victim wrote.
Okay, and now is the appropriate time for me to hear that victim witness impact statement. Ms. Clark, are you there?
Yes, Judge. My camera is going in and out, so I'm not going to turn it on.
Don't worry about it. If
Okay.
you'll do me a favor and just start by stating and spelling your name and role, and then the name of the victim, and then read me her statement.
I am the victim witness advocate. My name is spelled CHRISTEN, last name CLARKE. And I am reading the statement on behalf of Shania Jenkins. It's spelled SHANIYA Jenkins, JEKINS. And it states, Dear Judge, I was 13 in 2023. I was taken advantage of. I was touched inappropriately, and my body was touched in ways that I can't talk about because it was so bad. Every waking moment of my life, I think someone is out to get me. The defendant has caused me so much pain. I have issues with sleep because every time I close my eyes, I can envision what the defendant did to me. The defendant placed his private part somewhere he knew it did not belong. I am still traumatized physically and emotionally. The defendant took away my childhood and innocence. I always blame myself for what happened. I'm always angry and I don't feel safe around men. I hope one day he will realize the pain that he has caused me and my mom. I remember having nightmares and crying every day. I want the defendant to know I have very bad PTSD and really bad depression because of what happened to me. I'm putting my life back together slowly, and Judge, I'm doing better in school now. I pray I'm the last victim, and I hope the defendant does not ever get to do this to any child ever again. Thank you, Judge. Sincerely, Shania Jenkins.
Thank you, Ms. Clark. Mr. Murphy?
Thank you, Your Honor. Your Honor, I'll first say there was a lot of negotiation that went on with this, and I appreciate the time and effort of Ms. Potter in taking a very hard look at this case and agreeing to reduce it to the sexual battery count. I understand there was the DNA issue, but there were also some significant mitigating factors involved. Mr. Burks had just met the victim the day before. We know that it is not a defense, but he was given a different age by her, and then she came to his home with some friends the next day. So he takes full responsibility for his actions, but I do want the court to know that there were some significant mitigating factors that also go in to making sexual battery seem a much more appropriate charge that fits the facts of the case, fits the circumstances that were there, and fits the investigation that was done after the fact. Mr. Burks is 22 years old as he stands here before you, Your Honor. He is a lifetime resident of the Atlanta area. He went to North Clayton High School. He did not finish his senior year, but he is currently enrolled in a GED program as he stands here before you today. He also works full-time for Amazon in addition to that. He has never been in trouble before, Judge. He doesn't have a criminal history. So this was something that, you know, was out of the ordinary for him. And I think he would tell you he certainly did not want to harm anyone and is here with a significant amount of remorse and contrition as he stands here before your honor. When I first began negotiating with Ms. Potter, I did from the outset ask that she reduce this to sexual battery, and I did with a very straight face go to her and tell her that I thought probation was appropriate for the case for a negotiated plea. She obviously objected to that, and we're here with an understanding of what we're doing, Your Honor, but I do want the court to know why I went to her with that, and it was because of the issues with the underlying case, the facts of the case, the lack of a criminal history by Mr. Burks, and the significant support in the community and family that he has. I don't know if you can see the people in the courtroom, Your Honor, but I know you've seen in the past the significant number of people that come to court with Mr. Burks every time we come before Your Honor. His mom and dad are both here, his brother's here, his brother's girlfriend's here, his sister's here, his partner is here. Judge, she is actually going to be giving birth to a child expected on August 11th of this year, Your Honor. And all of those people are here to show support for Maurice because they love Maurice. And, you know, despite knowing these allegations against him, they stand by him. They know everything about this. They are all fully apprised of the case and know everything about it, and make sure that they are here to show up and support him at every possible opportunity to do so. Based on that, Your Honor, we are tendering the guilty plea. We do not have any objection to the full sentence being 10 years. We do not agree with the 3 years being appropriate in the case, Your Honor. We think given all the circumstances that was significantly more. I will say after we initially went to probation, Ms. Potter had a higher offer than she has come to the court with today. We did come forward and ask to do a negotiated plea at 10-1. We were not able to get there today. So we are asking the court for that. That is the sentence we are asking the court to pronounce. We do not have any objection whatsoever to the registry. I think that is required given the subsection that the plea is under on the sexual battery statute. We have no objection to a psychosexual evaluation. We have no objection to any treatment that is recommended that he will undergo diligently and be ready to do. Your Honor, we would ask if the court would consider sentencing him under the First Offender Act, given his lack of a criminal history. He does not have any prior sexual battery charges. And for purposes of the First Offender Act, a second sexual battery conviction would prohibit him. But given that he has no criminal history, he would be eligible for that. We have talked about the carrot and the stick of that at length, and he understands that and has absolutely no intention of ever being before Your Honor or any other judge ever again once he puts this situation behind him. So that is what we would ask, Your Honor, and Mr. Burke would also like to address the court as well.
Okay, before I hear from Mr. Burke, Ms. Potter, does the state have any objection to the court's consideration of that first offender?
Yes, Judge, we would object. And that is not something we even talked about during any of our negotiations.
Okay. Mr. Burke?
Your Honor, I thank you for allowing me to speak. I take responsibility placing myself in a situation I should have avoided. And I understand how serious this has been. This is my first offense, and this experience has been a wake-up call that has caused me to reflect deeply on my decisions. Since then, I have been focused on doing better. I am working a full-time job, enrolled in school, raising a 1-year-old, and preparing for another child on the way. I respectfully ask the courts to consider an alternative sentence to allow me to continue this progress while still held accountable. Thank you for your time, Your Honor.
Thank you, Mr. Burke. Mr. Burke, I just have, yes, ma'am, Ms. Potter.
Sexual battery is not eligible for first offender either, under 4260.
That's one of the reasons I asked you, because I wasn't sure, but I thought that perhaps it was not. So thank you for clarifying that, Ms. Potter.
Yes, Judge.
Mr. Burke, I have a few just follow-up questions for you, and it's mostly just to spot check what you've already been asked by the state. But you understand that you have a right to plead not guilty to these charges, correct, sir?
Yes, ma'am.
And do you understand that you have a right, if you plead not guilty, to have a trial with a jury?
Yes, ma'am.
And do you understand, sir, that at a trial, you would be entitled to be represented by an attorney, including one at no expense if you couldn't afford one?
Yes, ma'am.
And do you understand that at a trial, your attorney would be allowed to ask questions and to challenge the evidence that the state offered?
Yes, ma'am.
And do you understand that at a trial, you would not be required to testify as you're doing now?
Yes, ma'am.
And you understand, Mr. Burke, those questions that I've just asked you and most of the questions that Ms. Potter has asked you are about important rights that you have that you are giving up by entering this plea.
Yes, ma'am.
Thank you, Mr. Burke. So it appears to me that Mr. Burke has an understanding of what his rights are and that it is his intention to waive those rights and enter a plea. And so I will accept his plea as knowing, voluntary, and intelligent. And the decision-making process for how to sentence in a case like this is not an easy one. I suspect it's the same reason that the state and the defense weren't able to come to an agreement, because the nature of the offense to which you have admitted is so concerning and bothersome and problematic in our community. But I'm also faced with a young person who's not previously had legal difficulties, who has taken responsibility for those actions, and who has offered some evidence of mitigation, the extent to which, whether it's legally valid mitigation or not, but certainly factors that would have been a matter for consideration if the case had gone to trial. And so ultimately, the real question, although Ms. Potter mentioned to you that the court does have the authority, and you indicated you understood that, to sentence you anything up to the maximum that's allowed by law, which would be 10 years in custody. The court isn't going to do that. Really, the choice the court is making is between the 1 year that your attorney is seeking and the 3 years that the state is seeking. And under the circumstances of the case, given the lack of criminal history and the responsibility, the fact that Mr. Burke is here and is taking responsibility for his actions, I think I am inclined to err on the slightly lower side of that. And so what I'm going to do is sentence Mr. Burke on count 1 to the reduced charge of sexual battery under OCGA 16-6-22.1 to 5 years to serve 18 months in custody, and the balance to be served on probation. As to count 2, on the reduced charge of sexual battery as in OCGA, reduced charge of sexual battery in OCGA 16-6-22.1, I'm going to sentence Mr. Burke to 5 years of probation. Count 2 will be served consecutively to the sentence in count 1. In count 1, after the 18 months, the balance of that will be on probation. As we have already discussed, Mr. Burke is required to register as a sex offender, and he will be required to undergo a psychosexual evaluation and comply with any treatment recommendations that arise from that. And I also require that he have no contact with the victim. Mr. Burke, I do want to caution you and your family who've been so supportive of you that sometimes it happens that family members and friends have contact with the victim, thinking they're helping their family member. They're not. I'm just going to remind you that when I say no contact, that means no direct contact, no indirect contact, no social media, and no one else can contact that person on your behalf. All of that would potentially be a violation of your probation. As was discussed a moment ago, I don't know that I would be inclined to allow for first offender treatment, but I don't believe that I understand why Mr. Burke would seek that accommodation and that treatment. But I think Ms. Potter is correct that it is not allowed for these types of offenses. And so I don't know that the court needs to rule on that from a discretionary perspective because I don't think it's legally allowed. Excuse me. Beyond that, Ms. Carty had brought to the court's attention that there is some paperwork that Mr. Burke will have to sign, indicating some of the requirements of his registry. Ms. Carty, I have the paperwork I'm looking for, and this is something that I want to make sure we do correctly. I know Mr. Burke has to sign off on it, but there are a long list of potential special conditions that the court has to either require or not require. Is that correct?
Yes, Your Honor.
Okay. And so the form that I'm looking at for special conditions of probation, Mr. Murphy and Ms. Potter had the two of you discussed anything regarding the nature and scope of these special conditions? I mean, some of them, I understand the original charge was child molestation. The victim in this case was 13. Some of them apply more directly. Some of them might be a little less applicable. Had you had a chance to discuss those at all, Mr. Murphy, Ms. Potter?
We have not discussed those, Your Honor. I think the only one I would have a significant concern with is his own being able to reside with his own children.
Yeah, and I would agree with you and would strike through that requirement in subsection 2 that Mr. Burke would be allowed to reside with his own children, but not with any other children under the age of 18. However, note that application does allow approval in advance. And so, for example, if Mr. Burke were to live with family members and had a younger sibling, or if he were to live with a partner who had a child that was not his, that can all be approved, and the court doesn't necessarily have a concern with it. It just would need to be approved. The only thing I would be striking through is any limitation on Mr. Burke's ability to live with his own children. Beyond that, I feel like the parties could probably negotiate. Obviously, he wouldn't be allowed to have any contact with the victim. That's a special condition. And I feel like the parties might be able to discuss and agree on the application or lack of application of these other aspects. For example, I don't think it's necessary for Mr. Burke to keep a driving log. But I don't think anybody should pick up hitchhikers or hitchhike, which I think is always funny to me that one's included. But I would.
I don't think to the polygraph, you can take that off.
Okay.
No driving log, no hitchhiking, no the 900 numbers in post office.
Right.
And then everything else the state would like to apply.
Okay, so here's what I'm gonna read off, Mr. Murphy, if you're aware, and tell you what I would be inclined to apply, and let me know if you have any concerns. Count 1 is contact with minors, and that would be applicable. It's sort of the main limitation. Count 2, we've already addressed, which is he would be limited from residing with a minor other than his own children. But again, that can be approved in writing if it's other children, as in the circumstances I mentioned. The residence change, and that would be applicable. The victim contact would be applicable. I would not prohibit Mr. Burke's employment. I would not apply item number 5. I would not apply item number 6, item number 7, item number 9, item number 10, item number 12, item number 18, or item number 19. The rest of them would be applicable, Mr. Murphy.
That's agreeable, Your Honor.
Okay. Ms. Carty, did you get those?
Yes, Your Honor.
Okay, thank you. I believe that that would conclude this matter other than reporting instructions. And of course, we need to have these papers finalized and signed by Mr. Burke. Logistically, I'm sorry if it's going to be a little bit of a headache because I'm not physically there to have it printed for you. Are the parties able today, while you're in the courthouse, to secure the printout of those documents and Mr. Burke's signature on them so that they can be provided to the court we can provide them to Ms. Carty so they can be finalized? Is that something y'all can accomplish today, Mr. Murphy? I'm sorry, yes, Mr. Murphy and Ms. Potter?
Yes, Judge, if Mr. Murphy just hangs around for a couple of minutes, I'll get them printed and be right back.
Okay, excellent. And then the other thing is, in order to finalize the plea, you would need to sign the indictment, indicating that there's been a plea entered. And Mr. Burke, since you've not been provided with a copy of the indictment, you have previously reviewed the indictment with your lawyer. But in order to finalize the plea today, do I have your permission to sign your name to the indictment indicating that you have entered a plea today to the reduced charges of sexual battery?
Yes.
Thank you. Mr. Murphy, may I sign your name?
You may, Your Honor.
Ms. Potter, may I sign your name?
Yes, Your Honor.
Okay. Ms. German, did you have an issue or question?
Judge, I did. My apologies. Since all parties are there, Ms. Potter, is it possible for her to print out the indictment? If not, and they can just sign it since all parties are there. And once you scan back the conditions, they can be all scanned to me.
Okay.
If possible, Your Honor.
Yeah, I mean, if Ms. Potter, if you're printing something, if you could print the indictment and have everybody sign it, that would be great. If not, the record reflects that the court's authorized to sign that indictment on everyone's behalf. Anything else from the state, Ms. Potter?
No, Judge, just that we do, I guess, anticipate Mr. Burke going into custody today.
I'm aware of that. Mr. Burke and Mr. Murphy, we had previously discussed, Mr. Burke understands that he's going to go into custody today. If the deputy can go ahead and start the beginning of that process so that we can get you, get that process started, and then we'll get your signatures. And Mr. Murphy, does Mr. Burke have any time in custody previously? I mean, I'm happy he would be entitled to credit for that time if he does.
It was a very short amount of time, Your Honor. He was able to almost immediately bond out.
Okay.
I can probably tell you the exact, was it a day?
Like 5 days.
He believes it was 5 days, Your Honor. I'm sorry. I'm pulling it up now.
Well, our record will reflect what time he spent in custody, and he will be given credit for that time. I just wanted to put that on the record. Anything else from the defense, Mr. Murphy?
No, Your Honor.
Okay. Mr. Burke, when you are released from custody, where will you reside? What county?
Fulton.
Ms. Carty?
Yes, Mr. Burke, 48 hours after release, you're going to report to 276 Memorial Drive, Southwest Atlanta, Georgia, 30303. I will send the reporting instructions to your attorney and he could forward that to your family members.
Thank you.
Thank you all. That concludes this matter. And deputies, if you'll take Mr. Burke into custody, as I said, they'll be back. Mr. Murphy will be back in a moment to have signatures put on the appropriate documentation. Thank you all.
Thank you, Judge, and thank you for squeezing us in today. Appreciate it.
Thank you for getting that taken care of.
Thank you, Judge.
You're going to keep that.
Okay. For the two attorneys that are here for the discovery dispute, if you'll just give me 1 second.
Thank you, Your Honor.
Thank you, Your Honor.
Would that mean pick it just how long we can move the second fence if we can see the first?
Yeah, the judge.
Ms. Potter?
Yes, Judge. Yes.
If you can, you could go ahead and strike off the ones that, since you guys will have it in person while he's signing, please strike off the ones that are not going to be applicable for the special conditions.
Okay, Ms.
Hey,
Carter.
guys, I need my Zoom for another matter. So if y'all could maybe talk on the phone. Thank you. Mr. Becker, Mr. Watson, thank you for your patience. As you can see, I'm very much multitasking today.
Good morning, Your
Absolutely.
Honor.
It's a
I hope
very
your travels
interesting.
are for leisure and not for work.
Yes. No, I had my daughter needed to have oral surgery yesterday, so I'm in visiting where she is.
Well, we hope your daughter did well, Your Honor.
She's a trooper, so she did fine. Thank you for
Well, that's
asking.
always frightening,
Yes.
no matter how
So,
minor it may be.
Gentlemen, my understanding from my staff attorney, Mr. Freehoff, is that the parties in the Ronald Lightfoot versus Red Diamond Realty and Red Diamond Hospitality, case number 24CV011650, that you guys had a discovery matter that y'all wanted to bring to the court's attention.
Yes, Your Honor, and that's on the plaintiff, and I'd like to apologize for being casual. I I've been
Don't
at the
worry about it at
doctor
all.
since I've been at the doctor since 8 this morning and thought I'd be able to get home, but I
Don't worry.
fractured
This
my
is Well,
malleolus,
I'm
so
very sorry that that happened, and don't apologize at all, because this is not even a formal hearing. We're only doing it by Zoom for convenience sake.
wow.
It really is just an informal discovery conference that I typically do by phone. So
Well,
don't
I
worry about it.
appreciate that, but I always dress appropriately, and I didn't expect to be sitting at the doctor's office as long as I was, but thank you, Your Honor. Yeah,
Thank you.
this is real quick.
Mhm.
And the dispute is uh defense counsel scheduled a deposition of our expert neurosurgeon, Dr. Rafai. It was supposed to take place on December 9th and was canceled by Mr. Becker on December 8th. Uh, Dr. Rafai is a neurosurgeon, and of course he had already set aside time for this, rescheduled, blocked off his calendar, and he has a $2,500 cancellation fee. I've been doing this 31 years, and I have never run into a doctor that did not have such a policy. And I guess Mr. Becker's objection is I guess there wasn't a fee schedule uh, produced to him beforehand, and my understanding that's the basis of his objection. But that's it in a nutshell, Your Honor.
Thank you, Mr. Becker. Um, your turn, sir. And can you tell me what happened to result in the cancellation? Was it a scheduling issue, or was there something more substantive?
It was a scheduling issue on my part. I had a conflict arose. I'll be honest, I can't remember exactly what it was off the top of my head that I had to address. I canceled the morning of December the 8th. The deposition was supposed to take place the evening of December 9th, so well over 24 hours ahead of time. I think the bottom line here is that the plaintiff wants to enforce a cancellation policy with their expert that they didn't tell me about until after they claim I ran afoul of it. They never sent me this
Well,
agreement
I understand your
before.
concern. I understand your concern about that, but I mean, I have a couple of questions. So is this expert a practicing physician? I assume he is, and he's testifying in
Yes,
his
Your Honor.
capacity as an expert treater.
He's not a treater, Your Honor. He's an expert. He's a retained expert neurosurgeon.
But he is a practicing physician.
Yes, Your Honor.
Okay. And the reason I asked that question, Mr. Becker, and I'm going to hand it back to you, is just to clarify that typically practicing physicians, at least in my experience, the reason they have sort of generally understood cancellation policies is because, you can't generally schedule patients on 24 hours or 48 hours notice, although sometimes I guess you could. Mr. Becker, so are you intending to take this doctor's deposition in a rescheduled deposition?
I do, Your Honor, and that will lead to some further issues that I'm prepared to discuss. As far as custom is concerned, including doctors, I've seen experts with 24-hour cancellation periods. In fact, I'd say the majority of them are 24-hour cancellation periods that I've ever dealt with. I have seen some with no cancellation policy. I can't recall ever seeing one with a 7-day cancellation policy, but if I'd known about that,
I would have, made different decisions had I known about that cancellation policy ahead of time. I think the onus is on the plaintiff to at least provide it.
So,
Certainly the
Mr.
law.
Becker, sorry,
Sorry.
that's okay. What are the other concerns you have if and when the deposition is renoticed?
Well, the plaintiff has put me on notice that uh, they now take the position that we are going to have to pay both the cancellation fee and prepay for Dr. Rifai's time before he will agree to be deposed again. I think the law runs against both of those demands. Starting with cancellation fees, 9/11/26 requires the party obtaining discovery to pay a reasonable fee for the time spent responding to discovery by that expert. We look to federal law where Georgia law is silent based on our rules. There's a case out of Arizona, Eden versus Paul Revere Life Insurance Company, where the district court held that this whole cancellation fee issue was between the party who hired the expert, which was the defendant in that case, and the expert, but not between the deposing party, the plaintiff, and the expert. And it was wholly their affair. The court denied their request, said if the doctor or the defense counsel feel they don't know it, they cannot pay it. The doctor can take efforts to collect it in state court if he wants to, and the state court can enter an order on anything related to that. And of course, if Dr. Rafai wants to sue me for a cancellation fee, I think he's going to have trouble coming up with a contract with us providing for that fee.
So let me back up for a moment, Mr. Becker. If you were to reschedule today, this doctor's deposition, you're not objecting to paying him a reasonable fee for his appearance for that deposition. Am I correct in understanding that? Is your issue that you either can't get it scheduled or that they're expecting to reschedule it, not only that you pay for some reasonable amount of his time, but also that you pay the cancellation fee? Is that correct?
Yeah, the issue is not that I refuse to pay a reasonable fee, though I think his fee is not reasonable. The issue.
I've never met a doctor whose fee was reasonable ever. So,
Yes.
But
I'm fully prepared to comply with the rules, but I believe the plaintiff is not entitled, nor is Dr. Rafai entitled, to demand prepayment before he'll sit for his deposition, which is what the plaintiff is telling us, or that this cancellation fee is appropriate under the circumstances or authorized by 9/11/26 in the first place. The whole prepayment thing, it's very well established. I've got a list of 9 cases here that say that.
yeah, that's why I was clarifying and making sure I understood what your position was. So it still really does relate back to this issue of this cancellation fee.
It does. And, as far as the cancellation fee, the reasonableness of that fee, it's based on an hour. He's charging an hourly rate of $2,500 an hour. I've got another list of cases here. I'm happy to send these to you, Your Honor, but
I don't think it's necessary. Again, this is intended to be fairly informal, more of a discussion, and provide the parties with, insight into what the court's thoughts are on the issue if and when motion practice is necessary. So
yes, I'd just like to show my work.
No, I appreciate that. Preparation is good.
Yes.
Thank you, Mr. Becker.
So in that Eden case, it was an orthopedic surgeon. They took his rate from $600 to $800 an hour to $450 an hour. I'm seeing a case out of Colorado where the court called $2,000 an hour for a neurologist grossly extortionate and set it at $600 an hour.
I don't know what the age is on those cases, but given the nature of the inflation that we've seen in the last 5 years or so, since 6 years now, since the pandemic, I would imagine that there's some allowance to be made, but I also don't know that this is going to come down to a discussion of whether or not his fee, either for cancellation or for appearance, is a reasonable amount. That's a matter that can be litigated if it is necessary. I think it really, to my thinking, comes down to the issue of this cancellation fee. And so if you will accommodate me, I'm going to call on Mr. Watson for a moment. Mr. Watson, Mr. Becker's position, well, I agree with you that historically my experience has been that doctors have cancellation fees. But Mr. Becker's position is that this doctor did not disclose that there wasn't anything oftentimes in writing, you'll get when a doctor is identified, you'll get a CV, you might get a fee
Right,
schedule, that kind of thing.
right.
And that nothing was provided to Mr. Becker about a cancellation fee or the timing of cancellation notice to be inquired. Is that factually accurate? Number one. And then number two, what is your response regarding why that does or does not matter?
Well, it's standard practice. I mean, you know, like I said, I've been doing this 31 years. I don't know of a doctor. I haven't had an expert in the last at least 10 years that didn't, a doctor, medical doctor that didn't have a cancellation fee. Plus, we're talking about a neurosurgeon here. So, and their fees tend to be higher than, you know, than an orthopedic, a neurologist, even sometimes, well, orthopedic
Well,
surgeons are
which is
orthopedic
why I said
surgeons are that
I'm not.
they're in that stratosphere as well, Your
Right.
Honor.
Well,
So,
which is why I've already said to Mr. Becker, this is not
right,
about the reasonableness of his fee. If he wants to charge $2,500 an hour, then he gets to charge $2,500 an hour, and y'all
right.
can litigate that matter a different way at a different time. The issue
And
really is the cancellation fee.
and I'm sorry, Your Honor, I missed the last part.
That's okay. I said the issue really is the cancellation fee. And so it sounds to me as if think your position is, I've not heard you dispute that there wasn't a formal written notice of it, but that
He had
Mr.
not been
Becker should have anticipated it or expected.
yet. Yes, Your Honor, he had not been provided a fee schedule in advance. That is correct.
Okay.
But once again, it
So
was canceled. It was canceled the day before, and even and I'll be honest with you, I've been out of town, so I have not looked at his fee schedule recently. Even if it was a 7-day notice, the bottom line is it was canceled the day before.
Right.
And I haven't, I mean, when that happens to us, we pay the fee. We understand that, whether or not we've been provided a fee schedule in advance. So
I understand that, Mr. Watson, and I appreciate your frustration and the doctor's frustration, but I also feel like if when the doctor is agreeing to a date and time for deposition, that it behooves him to notify the parties that there is a cancellation policy and that a cancellation will incur a certain fee. And it doesn't sound like that was done here. And so I'm not inclined to enforce that cancellation fee for this past cancellation. Now, of course, I would expect that upon rescheduling, that the doctor would ensure that Mr. Becker was aware of the ramifications of any cancellation. And again, I don't really want to litigate the matter of the reasonable fee and whether $2,500 is reasonable, because again, I think that is, if you want to take his deposition for a neurosurgeon, you should take his deposition and pay the fee, and we'll deal with that later. But I don't think that the plaintiff, the defendant under these circumstances should be required to pay the cancellation fee. And perhaps the doctor will just be reminded that when he agrees to a deposition date, he should make sure that he is providing his cancellation policy so that, as Mr. Becker put it, he can make different decisions if that's what needs to happen. So that's going to be my ruling. If the parties need it documented in some way, let me know that. Otherwise, I expect the parties to go forward and operate based on my ruling. Mr. Watson, you can let your doctor know that the court has declined to require him to pay that cancellation fee.
I will,
Now,
and we don't need anything in writing, Your Honor.
Okay.
We follow
Excellent.
rules, so.
I appreciate that, Mr. Watson. Mr. Becker, anything else that you need from me?
Two things, Judge. One of them, I may need an order, and I'm trying to think it through. I've had doctors in the past, one doctor in the past who wanted us to pay for the time plaintiff spent cross-examining after we had finished, and it was a significant chunk of time, and they were threatening to sue me for it and make a bar complaint. I'm wondering if I might need an order under those circumstances. Would it be all right if I emailed later if I come to that conclusion with a proposed order?
I don't generally enter orders on issues that have not yet arisen. And so, right. But now I will say this, my staff attorney and I are widely available. And if you should find yourselves in a deposition with this doctor and he says, nope, I gave you 1 hour, I'm done. And he says he won't answer questions unless you pay for him to be examined by Mr. Watson. call my office and let me know, and then I might give you a ruling like what you asked for, but that issue hasn't arisen yet, and I'm not going to preemptively rule on an issue that has not arisen.
It's not
Thank
going to
you, Your
arise,
Honor.
Your Honor.
My second issue does not relate to Dr. Rafai. It may be more of a point of clarification than anything, but it dictates how my next 2 weeks look. The expert disclosure deadline in this case was in April. We received a new expert disclosure in October and 3 in mid-December for new experts. And my understanding is that wouldn't be allowed, for this late disclosure. It's more of the subject for a motion to strike, but if I need to depose these people, I need to know.
Okay, so forgive me, Mr. Becker, I don't know if that was actually presented to me in terms of an issue to be resolved in today's hearing. And generally speaking, if there is a scheduling order in place, I expect the parties to either abide by the scheduling order or to work out an amendment to the scheduling order that the parties can present. And the only guidance I can give you is this, that the procedure in my standing case management order is for the parties to discuss any amendments and to agree on it if they can. And if you can't, then bring it to my attention that you can't. Although, again, not going to preemptively rule on any issue, I will tell you that if we're talking about a fairly short window, that's unlikely to have been prejudicial because the parties still have time to accomplish depositions, et cetera, because the remedy never forget that the remedy to a late disclosed witness is to have an opportunity to discover that witness's information. That's always the remedy. And so unless it's really abusive or continuing, it typically does not rise to the level of, no, you don't get to have any of these experts. Now, I'm just telling you that generally in terms of what my understanding of the law is. And so what I would suggest is that the parties talk about the nature and scope of what that late disclosure was, if in fact it was a late disclosure, if there is some accommodation that needs to be made in terms of a 6.4 effort at good faith resolution of this issue. And if not, then Mr. Becker, it's entirely within you and your client's rights to make some motion regarding that issue. But first, I would expect you to have engaged in an effort to discuss the discovery accommodation in terms of an extension of discovery and whether or not that needs to be had, or then undertake whatever you would need to undertake on behalf of your client to seek to exclude those experts, et cetera. So.
Certainly, and I appreciate Your Honor. I wasn't trying to ambush anybody. My question may be more been along the lines of what's the court's usual remedy for a violation of that, because it dictates whether before discovery closes on the 30th, per the court's final scheduling order, whether I need to get those people lined up. So that was more of my question than
Understood.
actually asking you to weigh in on the merits of it.
No, and I appreciate that, Mr. Becker. I didn't mean to imply otherwise. It was more that I feel like there is some discussion y'all need to have. And of course, if you need to document, to paper your record the way, you are free to do that the way you want to. But if the parties can work it out, I feel like the parties should work it out. And again, I don't know anything about the facts or circumstances of it, but ultimately I can tell you that generally speaking on issues like this, that I'm confident that the case law is that the remedy to a late disclosed witness is to allow discovery for that witness. And in this particular circumstance, the question is going to be, what is the nature and scope of how late it was and why was it late and all those things. And if those are issues that the parties can work out, great. If they're issues the parties cannot work out, then you can bring it to the court's attention in through a motion or whatever, but that wouldn't be for today's matter. Anything else, Mr. Becker?
That's all I've got, Your Honor, and I greatly appreciate your time, especially considering the rescheduling and your travel.
Don't worry about it.
You've been
Mr. Watson, anything else from? Oh, I'm sorry. I apologize, Mr.
That was it. I was just saying you've been extremely helpful, and I thank you.
Okay, Mr. Watson, anything else?
No, ma'am. Safe travels home, Your Honor. Thank you for taking the
Excellent.
time.
Thank you all. Have a good day.
Wish
Bye-bye.
your daughter all the best.
Thank you.
All right.
Same for me as well.